Meghan has been granted summary judgment in relation to the outstanding parts of the Duchess of Sussex copyright claim during a remote hearing at the High Court in London. This morning, her lawyer once again faced the legal representatives of Associated Newspapers, ANL. During the hearing, Lord Justice Warby considered the remaining issues concerning the copyright of the letter she sent in August 2018 to her estranged father, Thomas Markle SNR. The copyright's ownership had been contested by ANL because her former communications secretary at Kensington Palace, Jason Naff, had seen an electronic draft of the letter. The publisher argued this led to the belief Mr. Naff was a co-author of the letter, adding it meant the letter belonged to the Crown. However, this morning the High Court heard that Mr. Naff emphatically denied being a co-author and that lawyers representing the Keeper of the Privy Purse, acting on behalf of Her Majesty the Queen, told Meghan's solicitors they did not consider the Crown to be the copyright owner. Representing Meghan, Ian Mill QC told Lord Justice Warby the Keeper of the Privy Purse's lawyers had written to Meghan's solicitors disclaiming any claim to copyright on behalf of the Crown. In court documents filed ahead of the hearing, Mr. Mill also said Mr. Naff's lawyers confirmed he did not write the letter to Mr. Markle and it has never been his belief that he was an author. His lawyers said, as reported to the court, Mr. Naff did not draft, and has never claimed to have drafted, any parts of the electronic draft or the letter and would never have asserted copyright over any of their content. In our client's view, it was the Duchess' letter alone. Mr. Mill added, this unequivocal statement of Mr. Naff's position also gives the lie to the defendant's inferential case, in its defense to both the privacy and copyright claims, that the claimant considered using the letter as part of a media strategy. Meghan, Mr. Mill said, had shared a draft of the letter with Harry and Mr. Naff for support, as this was a deeply painful process that they had lived through with her. He added, Mr. Naff was responsible for keeping the senior members of the royal household apprised of any public-facing issues, the media spectacle surrounding Mr. Markle being one such issue. He also told the court that Mr. Naff suggested that a reference to Mr. Markle's ill health be included, which Meghan did, but that Mr. Naff did not suggest any specific wording. Mr. Mill then sought summary judgment, later granted by the judge, to settle the matter without a full trial. Andrew Caldecott QC, representing ANL, did not oppose the summary judgment but added the publisher does not consent to summary judgment because its appeal against summary judgment in the copyright claim remains live. In written submission, Mr. Caldecott also said it was a matter of regret that the representatives of Mr. Naff had not said he was not an author of the letter before the summary judgment hearing in January. When Mr. Naff's lawyers told ANL that he was not a co-author, the publisher swiftly recognized the impact of the information in that letter upon part of its copyright defense, and indicated that it would not oppose summary judgment. Meghan's lawyers had already asked for a summary judgment to settle all of her claims without a trial in autumn last year. In 2019, Meghan sued ANL, the publisher of the Mail Online, Mail on Sunday and Daily Mail, over the publication of a series of articles including extracts from a handwritten letter she addressed to Mr. Markle. The Duchess claimed the 5 articles containing parts of her letter, published in print and online in February 2019 by the Mail Online and Mail on Sunday, misused her private information, infringed her copyright and breached the Data Protection Act. The lawsuit was announced by Prince Harry in a statement published at the end of the Sussex's tour to South Africa. In February, after a 2-year-long legal battle, Lord Justice Warby ruled ANL's publication of Meghan's letter to her father was manifestly excessive and hence unlawful. He granted Meghan summary judgment in relation to her privacy claim as well as most of her copyright claim. This meant she won that part of the case without having to go to trial. The High Court judge said, it was, in short, a personal and private letter. The majority of what was published was about the claimant's own behavior, her feelings of anguish about her father's behavior, as she saw it, and the resulting rift between them. These are inherently private and personal matters. The judge also said the only tenable justification for any such interference was to correct some inaccuracies about the letter, contained in a story featured in People magazine, which had been published just days before ANL's 5 articles. In the People magazine article, 5 unnamed friends of the Duchess of Sussex spoke in her defense. Meghan's friends, who as stated by the Duchess in court papers spoke to the U.S. magazine without her knowing it, were the first to reveal to the public she had sent a letter to her father. However, Lord Justice Warby added, the inescapable conclusion is that, save to the very limited extent I have identified, the disclosures made were not a necessary or proportionate means of serving that purpose. For the most part they did not serve that purpose at all. Taken as a whole, the disclosures were manifestly excessive and hence unlawful. In a judgment released in early March, Lord Justice Warby said the Mail on Sunday will have to publish a front-page statement and a notice on page 3 of the paper stating it infringed her copyright by publishing parts of the letter to Mr. Markle. An article will also have to appear for a week on Mail Online, the judgment added. ANL was also ordered to pay 90% of the costs incurred by the Duchess of Sussex for the summary judgment application in her legal battle.